Today I'm going to tell you about Supreme Court of the United States. It was while debating the separation of powers between the legislative and executive departments that delegates to the 1787 Constitutional Convention established the parameters for the national judiciary. Creating a third branch of government was a novel idea in the English tradition. Judicial matters had been treated as an aspect of royal executive authority. Early on, the delegates who were opposed to having a strong central government argued that the national laws could be enforced by state courts, while others, including James Madison, advocated for a national judiciary authority consisting of various tribunals chosen by the national legislature. It was also proposed that the judiciary should have a role in checking the executive power to veto or revise laws. The Judiciary Act of 1789 called for the appointment of 6 judges. Although an 1801 Act would have to reduce the size of the court to 5 members upon its next vacancy, an 1802 Act promptly negated the 1801 Act, legally restoring the court size to 6 members before any such vacancy occurred. As the nation's boundaries grew, Congress added justices to correspond with a growing number of judicial circuits, 7 in 1807, 9 in 1837, and 10 in 1863. In 1866, at the behest of Chief Justice Chase, Congress passed an act providing that the next 3 justices to retire would not be replaced, which would thin the bench to 7 justices by attrition. Consequently, 1 seat was removed in 1866 and a second in 1867. In 1869, however, the Circuit Judges Act returned the number of justices to 9, where it has since remained. A Supreme Court justice is appointed to the High Court for a lifetime term. When the Senate is in recess, the President may make temporary appointments to fill vacancies. Recess appointees hold office only until the end of the next Senate session, less than 2 years. The Senate must confirm the nominee for them to continue serving of the 2 Chief Justices and 11 Associate Justices who have received recess appointments. Only Chief Justice John Rutledge was not subsequently confirmed. The Constitution provides that justices shall hold their offices during good behavior unless appointed during a Senate recess. The term good behavior is understood to mean justices may serve for the remainder of their lives unless they are impeached and convicted by Congress, resign, or retire. Only 1 justice has been impeached by the House of Representatives, Samuel Chase, in March of 1804. But he was acquitted by the Senate in March of 1805. Moves to impeach sitting justices have occurred more recently. For example, William O. Douglas was the subject of hearings twice in 1953 and again in 1970. And Abe Fortas resigned while hearings were being organized in 1869, but they did not reach a vote in the House. No mechanism exists for removing a justice who is permanently incapacitated by illness or injury, but unable or unwilling to resign. Because justices have indefinite tenure, time into vacancies can be unpredictable. Every current justice has an Ivy League background. 4 justices are from the state of New York, 1 is from California, 1 is from New Jersey, 1 is from Georgia, 1 is from Colorado, and 1 is from Maryland. In the 19th century, every justice was a man of European descent, usually Northern European, and almost always Protestant. Diversity concerns focus on geography to represent all regions of the country rather than religious, ethnic, or gender diversity. Historically, most justices have been Protestants, including 36 Episcopalians, 19 Presbyterians, 10 Unitarians, 5 Methodists, and 3 Baptists. The first Catholic justice was Roger Taney in 1836, and 1916 saw the appointment of the first Jewish justice, Louis Brandeis. In recent years, the historical situation has reversed. Most recent justices have either been Catholic or Jewish. As of 2018, associate justices are paid $255,300 and the Chief Justice $267,000. Article 3, Section 1 of the U.S. Constitution prohibits Congress from reducing the pay for incumbent justices. Once a justice meets age and service requirements, the justice may retire. Judicial pensions are based on the same formula used for federal employees, but a justice's pension, as with other federal court judges, can never be less than their salary at the time of their retirement. Although justices are nominated by the President in power, justices do not represent or receive official endorsements from political parties, as is accepted practice in the legislative and executive branches. Jurists are, however, informally categorized in legal and political circles as being judicial conservatives, moderates, or liberals. Such leanings, however, generally refer to legal outlook rather than a political or legislative one. The nominations of justices are endorsed by individual politicians in the legislative branch, who vote their approval or disapproval of the nominated justice. Following the confirmation of Brett Kavanaugh in 2018, the court currently consists of 5 justices appointed by Republican presidents and 4 appointed by Democratic presidents. It is popularly accepted that Chief Justice Roberts and Associate Justice Thomas Alito, Gorsuch, and Kavanaugh, appointed by Republican presidents, comprise the court's conservative wing. Justice Ginsburg, Breyer, Sotomayor, and Kagan, appointed by Democratic presidents, comprise the court's liberal wing. The Supreme Court first met on February 1, 1790, at the Merchants Exchange Building in New York City. When Philadelphia became the capital, the court met briefly in Independence Hall before setting in Old City Hall from 1791 until 1800. After the government moved to Washington, D.C., the court occupied various spaces in the United States Capitol building until 1935, when it moved into its own purpose-built home. The 4-story building was designed by Cass Gilbert in a classical style sympathetic to the surrounding buildings of the Capitol and Library of Congress, and is clad in marble. The building includes the courtroom, justices' chambers, an extensive law library, various meeting spaces, and auxiliary services, including a gymnasium. The Capitol maintains its own police force separate from the Capitol Police, located across 5th Street from the United States Capitol at 1 First Street Northeast and Maryland Avenue. The building is open to the public from 9 a.m. to 4:30 p.m. weekdays, but closed on the weekends and holidays. Visitors may not tour the actual courtroom unaccompanied. There is a cafeteria, a gift shop, exhibits, and a half-hour information film. The federal court system and the judicial authority to interpret the Constitution received little attention in the debates over the drafting and ratification of the Constitution. The power of judicial review, in fact, is nowhere mentioned in it. Over the ensuing years, the question of whether the power of judicial review was even intended by the drafters of the Constitution was quickly frustrated by the lack of evidence bearing on the question either way. Nevertheless, the power of judiciary to overturn laws and executive actions it determines are unlawful or unconstitutional is a well-established precedent. Many of the Founding Fathers accepted the notion of judicial review. In Federalist Number 78, Alexander Hamilton wrote, "A constitution is, in fact, and must be regarded by the judges as a fundamental law." The 21st century has been increased scrutiny of justices accepting expensive gifts and travel. All the members of the Roberts Court have accepted travel or gifts. In 2012, Justice Sonia Sotomayor received $1.9 million in advance from her publisher, Knopf Doubleday. Justice Scalia and others took dozens of expensive trips to exotic locations paid by private donors. Private events sponsored by partisan groups that are attended by both the justices and those who have an interest in their decisions have raised concerns about access and inappropriate communications. Thanks for watching this Adventurous Kids episode.